Society, online defamation, and anti-SLAPP suits. My name is Tom Fair. I'll be moderating today. This is a presentation of the Cleveland Metropolitan Bar Association's Thought Leadership Committee. We do this the second Tuesday of every month, and our role is a convener of discussions regarding topics of importance to our community and to the legal community in general. We like to present topics that have some currency and some importance to decisions that have to be made, and we try to present two sides of a topic for everybody to listen to. Today we have two practitioners in the area of online defamation who are going to give us sometimes concurrent and sometimes differing views on these interesting topics. Our first is Tom Heron. He's an attorney at Frontier. He represents businesses of all sizes, from young startups to large publicly traded companies. Many of Tom's clients are highly scrutinized by regulators, journalists, and the public. And as a result, part of Tom's practice involves assisting his clients by developing public relations strategies to combat criticism and negative press through the effective use of the media and targeted messaging campaigns. He also likes to file anti-SLAPP suits. Our other panelist is Aaron Mink. He is a nationally recognized leader in the area of internet defamation and is known as the go-to attorney for the most malicious and challenging internet defamation crises. His work is on the technological forefront of removing damaging content from the internet, combating defamatory cyber attacks, and uncovering the identities of anonymous internet users. Aaron has developed cost-effective, cutting-edge legal solutions for his clients' most pressing and damaging online problems, while providing them with the peace of mind that these intrusive matters have been resolved. Well, or at least he hopes. Our first topic today is something called anti-SLAPP statutes. And anti-SLAPP statutes aren't assault statutes. They actually have to do with defamation and online conduct. So I'd like to start by asking Tom if you can describe for our viewers what is a SLAPP action.
So a SLAPP statute is a type of, or a SLAPP action rather, is a type of lawsuit that is not meant as you might think traditionally of a lawsuit, right? The person filing a SLAPP suit has no intention of really even winning the case. The purpose of a SLAPP suit is to stifle free speech, right? It's to chill criticism and other lawful expression. And so that's why we've developed this acronym. SLAPP stands for a strategic lawsuit against public participation. And that, again, gets to this idea that it's a plaintiff filing a lawsuit not to win on the merits, but to make it so onerous for the person criticizing him or her that they will just sort of give up, right? They don't want to go to a faraway court. They don't want to pay for attorney's fees. They don't want to go through discovery. So they'll just stop the criticism rather than fight the merits of a lawsuit. So you often see these types of suits. They'll do a lot of the same types of things. They might include just a ton of defendants or a ton of plaintiffs that are unnecessary to the action. You might see them base the action making sort of ambiguous or vague claims. A lot of times plaintiffs will just generally say, the defendant defamed me by making a false statement of fact, and my reputation was damaged. But they never really tell the court, well, what did that person actually say about you? Because their goal is just to haul you into court and to keep you from exercising your First Amendment rights. And another thing that some SLAPP plaintiffs do is they will target anonymous critics, and you find this a lot of times online, where somebody might have a pseudonym and be commenting on a news article, and they might criticize the subject of that news article, and then the subject will file a lawsuit, not because the person really defamed them, but because they just want to find out who's criticizing them online. And we've run into these types of claims in my practice specifically a number of times. One example I'll give you is we represented the blogger down in Steubenville that broke the story of the social media postings of the Steubenville football players that assaulted the young woman at a party in the now famous Steubenville rape case. She was the one who caught, the Twitter feeds and the pictures of them carrying a young woman out of the party, and she posted them on her blog, and she was reporting on what was going on down in Steubenville, and she found herself subject to a defamation claim filed by another football player down in Steubenville, but they also named the anonymous commenters on her blog that were discussing the case and the reporting, generally speaking. And in doing so, they sent subpoenas to the internet service providers to unmask those anonymous commenters. And you have to think about that in the context of Steubenville, right? And the Steubenville football program. I mean, Steubenville football players, the head coach, they're like gods down in Steubenville. And so to be unmasked as somebody that's criticizing the football players can really damage you in that community. When the New York Times went down to report on the story, a reporter from the New York Times approached head football coach Reno Sokoch in a parking lot. And she, in her story, relays this encounter where he gets up in her face and points at her and says, "If you don't get yours, then someone close to you will." Now, if the head football coach at Steubenville will say that to somebody that he knows is going to put that in the New York Times, what happens when you are a parent in the Steubenville community? Maybe you're employed by Steubenville High School. What will the reaction be like in the community if you are unmasked as somebody that's criticizing the handling of the case, the investigation, etc.? So that's an example of the way that SLAPP plaintiffs will oftentimes try to sort of unmask their critics. But you also see it in cases where they just want to stop the criticism. We already know who the person is. We just want to stop the criticism altogether. We represented a woman from South Carolina and a guy from Pennsylvania in a case filed by MedExpress. It was a Medina eBay seller. And the woman from South Carolina ordered a part. I was from MedExpress, and it arrived at her office with postage due. She had to pay like $1.08 or something. So she posted a review of the seller and just said, "Package arrived with postage due." The guy from Pennsylvania ordered a product, and then after he ordered it, the sale went through. He got a notification that it was out of stock, and he couldn't get what he had ordered. So he posted a review and said, I ordered something and then got a notification that it was out of stock. MedExpress sued both of them for defamation and sought a preliminary injunction in the Medina County Court of Common Pleas to force them to remove the statements and eBay to take the statements down themselves. We got involved in that case. The case was dismissed right away, but we moved for sanctions, and we litigated the sanctions issue for 2 years following the dismissal of that case. That plaintiff also sought a preliminary injunction from somebody in Guam that had posted a review. He wanted to haul the Guam defendant into Medina County Court of Common Pleas for filing a constitutionally protected review on eBay. And you have, numerous examples of these types of cases. One of the worst SLAPP offenders is Murray Energy, which is located here in Ohio. And you might, if that name sounds familiar, you might remember that he sued John Oliver when John Oliver did a story about Murray Energy, sued him for defamation, I believe, in West Virginia. Well, they filed a case in the 8th District here in Cuyahoga County, went up on appeal in the 8th District. Thankfully, Murray Energy lost. But in that opinion, the 8th District took the extraordinary step of calling on the General Assembly to enact an anti-SLAPP statute here in Ohio.
So what is let me interrupt you for a minute. So we know what a SLAPP action is. What is an anti-SLAPP statute?
So an anti-SLAPP statute is a statute that has been enacted in almost 30 states. And these are statutes that require courts to award mandatory attorney's fees against SLAPP plaintiffs. So if somebody's facing a SLAPP suit, they can file what sometimes is called a special motion to strike or a special motion to dismiss that will force the court to reach the constitutional implications of that claim. And if the court finds that this is a baseless, frivolous lawsuit, then the court has to give the defendant his or her attorney's fees in defending the action. it's not unlike a normal frivolous conduct sanction statute like we have here in Ohio. But as many practitioners will know, getting sanctions under that statute is like seeing a unicorn, right? You always hear about them, but you never see them because courts are loath to sanction the attorneys that practice in their communities. So these are laws that have been enacted and require courts to award attorney's fees if somebody files a baseless SLAPP action.
So not all states have an anti-SLAPP statute, so there are presumably states where you can feel free to slap anybody at will. Is that right?
Well, that's the problem, right? Is, you know, here in Ohio, we don't yet have an anti-SLAPP statute. So defendants like the people that we represent and defendants that other people represent, they do find themselves having to go through the onerous burden of hiring an attorney. You know, maybe they can't afford an attorney. Maybe they just don't want to go to court for exercising their First Amendment rights. They don't want to give up information during discovery. Maybe they don't want to be unmasked for criticizing somebody you know, important in their community.
Aaron, tell us, are anti-SLAPP statutes always a good idea?
Sure. Thank you, Tom. And you know, I think obviously I'm coming from the plaintiff's perspective, and I represent people who are defamed online or maliciously attacked online and have things posted about them that are negative and unfair. And the internet nowadays has consequences when people go and they engage in illegal and illicit or tortious conduct online. It can really affect people, not just online, but in the real world. And that's just a fact of life. So I'm definitely coming from the counter perspective here. Even with that in mind, I do feel strongly that some anti-SLAPP provisions and anti-SLAPP laws are very good. Certainly, I don't see any reason why lawsuits to challenge citizens' participation in government or politics or challenging public speech dealing with the government or laws and legislation that is being passed could ever be a bad thing. To really hold that to a, you know, and it involves a larger public interest. I don't think there's a really good argument to say, oh no, that's bad. You know, I think that's some of the most important things that we can do as a society is participate in government. But as someone who's practiced in this field for a while, what I can say is that there's definitely another side of the coin. And when you start getting into private speech with private individuals, you can run into a lot of flaws with these SLAPP statutes. One of them is that they can be very broad and they can be very ambiguous in the types of speech that they protect. And what starts as a well-intentioned law to protect people from frivolous lawsuits for First Amendment constitutional speech turns into lawsuits and SLAPP actions that involve things that have almost nothing to do with speech generally and are only tangentially related and actually deal with contract disputes and deal with completely unrelated actions. So there are a lot of really unintended consequences that can happen with these statutes at times when they're broadly worded. Texas, for example, they just recently amended their SLAPP statute just a couple weeks ago. They had a very, very strong, very broad SLAPP statute, and they found that people were using it involving attorney malpractice lawsuits, and they were using it in, you know, trade secret lawsuits, and you know, all of a sudden you can broadly word any type of, you know, legal action that suddenly comes within, you know, the definition of a utilization of speech or other power. So that's certainly one of the things that I'm very cognizant of, that I think can be a big downside of SLAPP suits if they're not worded correctly. Another point would be that they can just be used as a delay tactic, which can be very detrimental to victims in society today when they're being stalked and harassed and bullied online in ways that are tortious. I was involved in two cases in Texas, for example, where we were dealing, and we still are dealing with, a case that's going to trial shortly with with a woman who stalks and defames men online who she meets on Match.com. Creates a lot of fake names and aliases, targets certain types of professionals, and it took a great deal of effort to identify her. We had to send out subpoenas to maybe a dozen different organizations, and we lucked out with 1 or 2 IP addresses. And when we did, she went into court and filed a SLAPP suit, which not only, a SLAPP motion, which not only held up discovery without any good cause or reason, and prevented us from getting any further evidence to identify her and tie her to half of the very malicious actions that she'd done with, fake police calls and other items. But, she then appealed it on top of it. And, it was a unicorn. We did actually wind up getting over $100,000 in attorney's fees for her frivolous SLAPP suit, but it could have destroyed our case in the process. It almost did, is what the moral of the story was. And I think it was the first time in Texas case history that I'm aware of where anyone had ever, the plaintiff had gotten attorney's fees after a defendant filed a SLAPP suit. So I see a lot of, I have a lot of problems with very viable cases that happen that are held up, or it could potentially kill someone's ability to identify if they have a viable claim. And then, maybe the last thing is that there are absolutely baseless cases that need to be thrown out of court a lot sooner that get filed. But defendants are awarded fees as a result of a SLAPP suit or of a SLAPP case, not just because a case is baseless. They get awarded fees simply because they win, which is not normal in American jurisprudence. You can have a case which is a very close call. Opinion cases, opinion defenses, whether something constitutes opinion, can often be a toss-up. Calling someone or a service a scam, for example, or using words that are fairly hyperbolic but can also be tied to objective facts and opinions, can be very close calls. And if you lose that as a plaintiff after a defendant files a SLAPP suit, you didn't have a frivolous case, it was close. And you know what, you lost a tough one, but now, not unlike a regular lawsuit, you gotta pay the other side's attorney's fees for that, which wouldn't have normally happened under normal situations. So I think that's a tough call, and that there should be maybe some sort of other side of the coin where if you win and you get overcome it, maybe you can collect fees too, or there's some sort of objective standard which you don't just get, the other side doesn't just get fees just because they won at the end of the day. So I have a little bit of a problem with that, but you need a deterrent for also, so it's a balance. But I guess those are three problems that I typically have with SLAPP suits.
So I'll tell you a story about a case I had. We defended a company that manufactured a mobile app, and there was a plaintiff's class action law firm that started advertising on Facebook, telling everybody who had the app that the app violated the Wiretap Act, the Federal Criminal Wiretap Act. And my client wanted us to sue these lawyers and stop them from saying what was false, and it actually was false, but they were trying to get their class together. Tom, should we be able to stop that kind of discussion?
Well, I think the important thing to consider is that a SLAPP suit or SLAPP statute it's not designed anyway to stop viable claims, right? The idea behind a SLAPP statute is that we want the court to address the merits of the case earlier on in the process, so that we're not waiting until summary judgment, for example, before the court makes a decision on, okay, this was or was not constitutionally protected speech. So the way that SLAPP statutes are designed is we're getting those decisions earlier in the process. A well-designed SLAPP statute will allow viable defamation claims to proceed if somebody posts online, says Tom Herron committed a crime and I saw him do it, right? It's a false statement of fact, right? That's a, we hope. Right. So if that, if it's a viable claim, if a false statement of fact can be the basis for a defamation action, a SLAPP statute won't stop that lawsuit from proceeding. What you run into is somebody posts online and says Tom Herron's a bad lawyer, right? Clearly a matter of opinion, constitutionally protected.
But a wrong.
But a very bad opinion, right? But it's constitutionally protected. I can't sue somebody for that. So if that happens, and if I file that lawsuit, there should be a mechanism for the court to say, wait a minute, Tom, you're not going to make this person go hire another lawyer and go through all of that process. I'm going to get to the bottom of this right now.
Now, in our case, the defendant also said that besides anti-SLAPP, that they had a fundamental First Amendment right to say what they had, and that protected them from any liability for these defamatory statements. Aaron, do you think that's a viable defense?
It depends what state you're in. Generally speaking, you certainly, I think, have a First Amendment right, and that's absolutely true, and that is a defense. But it really comes down to, at the end of the day, the elements of a defamation claim. Is it a factual statement? Is it opinion, right? And it's almost baked in, whether or not something is an opinion, whether or not it's true or false. Because if it's false, then it's not a First Amendment defense. So you just resort back to the elements of the claim at the end of the day, in my opinion.
So here we are in Ohio. We're naked. We don't have any protection against SLAPP suits. What's the legislature doing about that, Tom?
So the General Assembly previously introduced a bill known as the Ohio Citizens Participation Act. It was introduced in the last session of the General Assembly. We expect very soon that a modified version of that bill will again be introduced, probably within a matter of weeks. And the Ohio Citizen Participation Act is modeled after SLAPP suits in other states. One of the unique things, though...
Can I interrupt you for a minute? It's modeled after statutes in other states. Have all those other states had their acts upheld?
In some form or another. I mean, there are a number of states, as Aaron mentioned, that have faced some constitutional challenges, rights to jury trial, for example, courts reaching factual issues too early in the case under certain SLAPP statutes. So there have been portions of various SLAPP statutes that have been challenged.
Certainly in 2 states, it's been eliminated. I know in Washington, it was completely declared unconstitutional as a whole, but I think only 2 states it's been successfully challenged and eliminated. And I don't know about the other one was maybe Maine or Minnesota. I don't know if certain only aspects of it were deleted or not. I'd have to look into that one. I'm not familiar with the situation.
So what constitutionally strong thing is our legislature going to do?
So the Ohio Citizen Participation Act is unique in that most SLAPP statutes limit their protected communications to statements relating in some way to an issue of public concern, right? It's the idea of somebody's going out to procure government action, or they're making a statement about an issue of public interest, right? Ohio's bill would protect communications coextensive with the First Amendment and Ohio constitutional protections for free speech. So it would protect a broader range of statements than you might find in other states. It would include the standard provision of allowing a citizen to file a special motion to strike if they're faced with a SLAPP suit. It would force the court to basically stay discovery unless the discovery is necessarily related to determining the outcome of that special motion to strike. It provides a briefing and decision schedule in the event that there's not a standard order from the court, or there's not a sort of special briefing schedule, so that we don't have courts that sit on special motions to strike and allow them just to kind of stay there for a number of months. And if a defendant is successful in getting their special motion to strike granted, it would require the court to award attorney's fees to the defendant. And on the other hand, if a defendant files a frivolous special motion to strike, the court still retains its discretion to award the plaintiff attorney's fees. For example, if the defendant is using the special motion to strike as a delay tactic. And it would also make denials of special motions to strike immediately appealable, so that somebody who's exercising their First Amendment rights, if their motion is denied, they can immediately go to the Court of Appeals for review. And one of the other unique things that Ohio's anti-SLAPP statute would do is that it would permit the filing of what we're calling or referred to as foreign SLAPP claims. The idea being that there's an Ohio resident who posts something online and somebody in a state without an anti-SLAPP statute files a SLAPP claim, right? It's a business in a state that somebody's just criticizing online. And so they get sued in a faraway state for a statement that would be protected under Ohio's anti-SLAPP statute. Let's say the person doesn't participate, and the person in the company or the plaintiff in the other state gets a judgment. Under this bill, the Ohio resident could file a new lawsuit here in Ohio seeking damages for the amount of the judgment in the other state, because that judgment would have violated Ohio's anti-SLAPP protections. So the idea being we want to prevent forum shopping, right? I mean, anti-SLAPP statutes generally, and certainly this bill, reflect a policy decision that legislatures make because of the unique aspects of cases involving the First Amendment, right? It's the First Amendment because it's a really important one. And so it reflects a policy decision that we want to make it easy for people to exercise their free speech rights. And we want to make it difficult, in many instances more difficult than if this were just a general negligence claim. We want to make it difficult to attack the exercise of those First Amendment rights. And Aaron brought up a great point in that you get mandatory attorney's fees even for cases that may not be frivolous. If it's a close call between if it's a matter of opinion or an issue of fact, the defendant, if they prevail, can still get attorney's fees because we've made the policy decision that we want to make it easy for people to speak, right? We want to err on the side of protecting the free exercise of speech, even in those close cases.
Aaron, should we be calling our state senators and urging them to vote for this bill the way it's drafted?
I'm obviously not in favor of Ohio passing an anti-SLAPP bill. I don't think I could have checked. It was a very limited bill, as I said earlier, that dealt with very high public interest in governmental actions and things like that. That's tough for me to even oppose, but certainly would make my job a lot harder, a lot riskier for my clients if attorney's fees were on the line in almost every case, for example. I think, in a broader picture, the reason why many states have passed anti-SLAPP laws is because they needed them. California was one of the first states out there that did it, and they did it because there was just a rash of dozens and dozens of lawsuits where big corporate interests were coming in and big money pockets were coming in, and they were just suing people completely frivolously with no intention of winning, just to shut people up. It was defamation, and they had such a rash of frivolous suits that the legislature acknowledged that, and they went in and they passed this because they said enough is enough, cut this out. We got to protect the little guy in here. So it was a very good idea for California because they had so many of these types of cases. I don't know if the same thing applies in Ohio. I think in a lot of these cases, even the ones that Tom mentioned earlier, one of the cases ended pretty quickly. They litigated attorney's fees for 2.5 years, right? That was kind of a discretionary appeal and lawsuit and everything else. You didn't have to go after attorney's fees, something that's very hard to get. Another case involving where I believe is the Murray case, where the court actually brought up in their decision that Ohio should have. It's just that Ohio should have an anti-SLAPP statute, so cases like this can be brought to justice earlier. even in that case, that I believe an insurance company was paying. You know, I don't think we have a SLAPP problem in Ohio. I'm not saying that these cases don't exist. They do. They're always going to exist. That's why these things get enacted. But Ohio is a state that has very strong legal protections for speech and opinion from the get-go. Unlike other states out there, we have the ability already, or defendants already have the ability to file counterclaims for frivolous SLAPP cases. You can, as a defendant, if you're sued frivolously for a defamation claim, you can file an abusive process action as a counterclaim, and if it is frivolous, you should prevail. So you already have a countersuit available to you. The other thing that Ohio has that not every other state has, I would say, is they have stronger protections for speech and opinion than we have under the Ohio Constitution than we have under the national Constitution, the U.S. Constitution. So in Ohio, we take speech very seriously. It's already a very defense-friendly. The cards are already stacked incredibly in favor of the defendants to begin with. Everybody loves free speech cases. Everyone's always on the side of the defendant. Let me tell you, because everybody loves free speech. So plaintiffs are always the underdog from the get-go, usually. So
everybody loves free speech. I have a client that didn't love it that much.
Well, right. You don't love it. Once you're the target of it, you don't love it so much. But it's hard to find a defamation-friendly judge. I'll put it that way. In the public at large, everyone likes to go online and talk now and chat and talk to their friends, so everyone can commiserate with plaintiff. So it is just really stacking the deck, in my opinion, unfairly. And it's really leveraged right now, the new legislation by a couple First Amendment attorneys. I believe Yelp from California is involved. And then some people who represent insurance companies, because the insurance companies are tired, in my opinion at least, are tired of paying out claims, defending broadcasters occasionally, once in a while, from a very frivolous lawsuit that might be filed against them. So I'm okay with a limited one, but I think anything beyond just a limited SLAPP is just unnecessary in Ohio. We don't have a problem at the end of the day.
I'm going to push back a little bit on the idea that these statutes are sort of bankrolled or supported mainly by insurance companies. One of the largest groups of supporters for Ohio's anti-SLAPP statute are advocates for victims of domestic violence. Because what you're starting to see, and this is an increasing trend, is a woman makes a report of domestic violence. They seek, whether it's a civil protection order, or they, tell their friends what happened to them, right? As soon as they sort of come out that they've been abused, there's an increasing trend of their abusers filing defamation claims against them. And so then what happens is you have these victims who now are sort of being re-victimized by having to go through this new civil process, while they might even have a pending civil protection order, or they filed police reports, etc. There's a reason why we want to protect speech like this, because generally speaking, when we restrict speech, when we restrict the ability of people to speak freely, it hurts the most vulnerable among us, whether it's a government restriction on speech, punishing people criticizing the government. You see SLAPP suits filed quite often by elected officials, members of city council who want to criticize, want to attack somebody that criticized them either at a council meeting or sort of elsewhere in their community. So that's why we make the policy decisions that we make in favor of free speech, because the protections are there to help those people who don't have the opportunity to speak as freely as somebody with a law degree or a lot of money might be able to.
Let me ask you, the example you gave early on, some of the defendants were anonymous, and I'm wondering, Does the Ohio statute deal with what we do with people who want to voice their strong opinions criticizing somebody but don't quite have the backbone to acknowledge that they're the ones saying it?
So I'll start with some sort of broad context. Anonymous speech is protected by the First Amendment. It goes back to the founding of our country when Publius wrote the Federalist Papers, right? There was a reason why the Federalist Papers were written anonymously, because they were criticizing the crown, right? They wanted to, they were out front and on a very hotly debated topic, and there were real world consequences for the positions that they were taking in those documents. It's the ability to speak anonymously has been protected by the First Amendment since the First Amendment was written. But those protections have not always been codified in statute. There's starting to be some case law developed throughout the country, starting with a case called Dendrite International versus Doe. That was a New Jersey appellate decision that sort of developed this test that has been applied in various states where before somebody wants to unmask an anonymous commenter, whether by a subpoena or by suing them directly, they've got to give the anonymous speaker notice that their identity is being sought. You have to allege with specificity exactly what you're alleging that person has said that is defamatory. You have to show that it can serve as the basis for a viable claim, and then you have to produce evidence supporting your claim. And then only after you make those showings can you unmask that anonymous speaker. The Northern District has a similar test where the Northern District requires plaintiffs to basically satisfy a motion to dismiss standard before they will allow a plaintiff to unmask an anonymous speaker. The last version of the Ohio Citizen Participation Act codified those protections and even included some draft language that was required to be included within that notice to the anonymous speaker as a condition of unmasking them. It does not look like those protections will be included in this new version of the bill. So Ohio, like every other state, will have to rely on precedent, from courts on that issue.
Aaron, is that a good thing that we make it difficult to unmask anonymous defamers?
So
anonymous speakers.
Yes, defamers, speakers, perspective. So I'm not opposed to a very small hurdle of obviously showing that you can state a claim under 12b-6. Just that it's just not completely frivolous garbage that you're asserting to try and unmask someone that has a right to speak anonymously. But I'm very wary of courts that develop precedent that gives big hurdles to overcome to unmask someone, because the deck is really stacked against the victims again, as usual, because you have the normal issues that it's a speech case or it's protected speech activity. Before it was criminalized, you could even make an argument that publishing naked photos of another person online is a protected means of speech to express a point of view before it was criminalized by revenge porn. So you can start drawing in a lot of issues that are way overbroad. And in the meantime, you've got my primary concerns are proving your case. You might have one shot to get to unmask someone who's doing very horrible things to another person and is engaged in terrible misconduct, and they can really logjam things by going into court and filing objections and preventing plaintiffs from being able to pursue remedies at the end of the day. This actually just happened in another case in Texas involving a Glassdoor review that was put up, or some Glassdoor reviews that were put up. And I'm not going to speak to the substance of the case and whether they were good claims or not, because I haven't really learned about that. But what was significant to me was that the case got held up on appeal for so long trying to unmask the person that even once they identified them, they wouldn't be able to sue them because the statute of limitations had run out. So if you can just run the clock long enough, and went all the way to the Supreme Court, and then the Supreme Court said, well, even if you unmask, the issue is moot. So I think that if you want to identify someone, you have to be aware of your remedies. You have to spend tens of a lot of money on legal fees to get in there, and you got to send out subpoenas. You got to hope that the evidence is there, that it isn't spoliated, and then to have someone just put up a big hurdle, which could just screw up the whole case. When you have valid claims, I think is very concerning to me personally. But there should, obviously be some very basic protections that you can't just get someone's identity with frivolous claims either. There is certainly good counterpoints and things for that. So that's my feelings.
Yeah, good points. I want to shift us because we're getting a little short on time and talk about our other topic today, which is different legislation known as the Communication Decency Act. Now that to me sounds like something Congress would have passed in the 40s to keep movies rated G, or maybe just directed at some of the emails some of my partners send to one another. But that's how it is. So before we talk about that statute, I'd like to talk about a specific case that Aaron, you know about. Could you tell us a little bit about the Grindr case?
Sure. So there's a really interesting case that was just decided out in the Second Circuit, where Grindr was sued by a young man named Matthew Herrick. I actually know the lawyer who represented Mr. Herrick, Gary Goldberg, and it was a terrible situation. Mr. Herrick went on Grindr and met someone there and dated the person, and when the relationship ended, the ex-boyfriend then went on and decided to harass him very maliciously using Grindr. And if you don't know what Grindr is, it's a dating app for homosexual men, kind of like Tinder. I don't know if people know what Tinder is, but what this person would do is he would go on and he would create a bunch of fake profiles on Grindr, and then he would basically send hundreds to thousands of men to his ex's apartment to show up and act like they're there for a date or a fling or for drugs, and he would send hundreds of people there, and it didn't stop. It wasn't like he did this once or twice. He would put up ads. He would have conversations with people through the apps, and he would act like he's really interested. He's like, yeah, come over to my apartment right now, and Matthew Herrick is having, from my understanding, just hundreds of people show up to his apartment on a daily basis or over a month period, where anything could have happened. It was putting his life in danger. So they went to Grindr, and they're like, you got to stop this. Like, we can't continue to have this happen. I'm in danger here. My life's in danger. And Grindr tried to do a couple things. They tried to block some IP addresses associated with this user. When they were alerted of fake profiles, they would delete them. They did what they could, but it wasn't enough. And what happened was Herrick filed a lawsuit against Grindr and said, you need to be held responsible for all the pain and damages that I'm incurring from your app, which is destroying my life. And the case was thrown out, and he lost because of the Communications Decency Act. Because you can't sue online providers like Grindr in this situation. It was a terrible situation. It was, though, at the end of the day, under the law, current law, a very easy result. One of the more interesting arguments in the case was that, well, I'll get into that in a second. Tom, do you want to talk more about the Communications Decency Act? Or?
Sure. And when we talk about the CDA, we're really talking about one provision. It's Section 230 of the CDA, which basically says a website operator can't be held liable for content that somebody else puts up on the website, right? And this traces back to does anybody remember message boards on the internet? Right? Remember when that was like the only thing that was on the internet? You know, it was Yahoo and message boards. Well, what started happening is people would go on these message boards and they would start talking and they would start defaming people and start putting up objectionable content. And people started suing the operators of the websites. And the website operators started losing. And they started getting held liable for all of this content that was put up there by other people, even as they were trying to go through and sort of edit and keep people from posting those things and take information down. And that editing capacity actually worked against them in the lawsuit. So Congress enacted this statute as a way to immunize website operators. The goal being that once they have this immunity, they will be able to more freely police their platforms, right? They can enact standards and take down objectionable content because they're not concerned about being treated as somebody who is now responsible for all of the content on their website. They're not worried that if I take this down, but I miss this problematic statement, am I going to be deemed to have sort of approved the statement, right? Or that I want it now on my platform, or I'm encouraging that kind of content.
Just we have a proud tradition in this country of using lawsuits to force big companies to pay attention to how their consumers are being harmed, whether it's through product liability law or other ways. If we enact a statute that says you can't be liable for anything that happens on your website, haven't we just taken away any incentive to have them police it and protect people?
See, I don't think so, because there still are going to be market forces, number one, that are at play. But I think the opposite is probably true, that if we remove their ability to police their platform, and we repeal the statute, one or two things is going to happen. Number one, they're going to stop policing their platforms altogether. And then every website is going to be the comment section on cleveland.com. Or you're not going to have the internet as we know it, right? It's not going to be worth the risk to companies to have this sort of interaction with their users.
Is that an interaction with the user?
Or to allow users to interact with their platform, sure. I mean, if you're going to hold Facebook liable for everything that somebody posts on Facebook, it's not going to be very long before nobody's posting anything on Facebook, right?
Would that necessarily be a bad thing? Aaron, is the Section 230, is that, when was that enacted?
Around 1996.
And does the internet look anything like it looked in 1996?
It does not.
And should Section 230 still look the same way it did in 1996?
So the Communications Decency Act is tough, because as Tom was saying, it really is the linchpin of the internet. If we didn't have that law, we wouldn't have the internet as we have today. Just plain and simple. All these companies would get sued to death. Google wouldn't exist. Facebook wouldn't exist. It just wouldn't exist. They would have been sued, or it would just be a giant cesspool of garbage, and it would be not what we like about the internet, primarily, I would say, or what most people like. So I don't think anyone should ever think to themselves like that. Usually the people who don't like the CDA are people who have stuff about them online that they don't like. And that they want down, and they can't sue these platforms because they're protected. Most people generally like the internet, but to get back to your questions, I mean, there are arguments now that the internet, when this law was passed, was largely in its infancy. You had these tech companies, Facebook didn't exist for another 10 years at that point, probably longer. And now you have these billion-trillion-dollar enterprises like Google and Facebook, where do they really need those same protections now? At the beginning, it was certainly really important because we needed these companies protected to spur innovation and to be able to have it so these companies could grow and we could do all these things. But these are big boy companies now. These are the biggest companies and the most powerful companies in the world. Do they really need to be immunized from every lawsuit that's filed against them at the get-go? Why can't they just treat them like normal companies and people and normal lawsuits.
And Tom, let me ask you this: if Facebook has enough technical savvy to figure out everything I do and sell it to somebody else for profit, is there something wrong with saying that they ought to use that same savvy to protect people against improper use of their platform?
So a couple of comments. Number one, I think Facebook's already doing that, right? And you already see Facebook, Google, Twitter, Instagram. They're all developing new algorithms and new technologies to cut down on cyberbullying, hate speech. I mean, that was a big part of Facebook's recent, whatever their unveiling is, when they unveil new products and new technologies. They spent a significant portion of time talking about, specifically on Instagram, ways to identify before somebody posts a comment if it's to identify if it's cyberbullying, and then they get a bunch of pop-ups like, do you really want to post that? And ways to kind of flag that content before it even gets posted onto their platforms. And that's happened.
They warn the bully before the bullying?
Yeah, well, so well, they do. Part of the idea, and I think Facebook does this to a certain extent through all of its platforms, as well. There might be a message about self-harm, for example, right? If you're posting something, there are technologies that are out there where you can identify, hey, here's a resource that you can turn to, and that's happened with Section 230 remaining in place. But I also don't know how much we want to push this idea of sort of corporate regulation of speech on these platforms that are now essential to everyday life, right? I don't know that I want Facebook necessarily telling me what I can and can't say on their platform, because what happens if I want to say something that might not be in Facebook's interest? What if I want to criticize a product that they have an investment in? Or what if I want to take a policy position that is adverse to their sort of outlined policy goals? So I think we need Section 230 to have this sort of continued open and robust debate and the free marketplace of ideas just sort of in the digital world now. And Section 230 was absolutely essential to that.
Aaron, does Section 230 or the ideas behind it have to be an all or nothing proposition? I mean, we've over time developed limitations and contours to free speech, to product liability law. Can we do the same thing on Section 230?
I think that's an ongoing debate that's happening right now, and I would say that we can do a little bit more. I would hate the problem is, and I'll take a counterpoint and then kind of reinforce the other side a little bit, is once you hold a provider accountable for a certain type of speech or a certain type of content, it shuts down that platform. The provider is no longer interested in providing that information anymore because they can be held liable for it. A prime example, which I consider to be a good thing to some extent, is Congress finally passed maybe one of the I don't know if it was the First Amendment or first big change to the Communications Decency Act last year or year before, where they finally said, look, if there is knowledge that things relating to child sex trafficking are happening on your platform and you don't take action and you have knowledge of it and you don't remove it, you can be held civilly liable and criminally liable. Before platforms were allowed to skate and have full knowledge that advertisements on Backpage or on Craigslist were advertising child sex trafficking, and they could just sit there and not do anything about it, which is not the reason why the Communications Decency Act was enacted. It was enacted so companies would take action without fear of retribution or lawsuits for removing harmful conduct. And Congress eliminated that protection for that particular type of content. And what happened the very next day, Backpage.com shut down. So, which, I mean, it goes to both sides, because once you eliminate those protections, well, you're eliminating all speech related to that thing. And obviously, when you have an evil like child sex trafficking, that's not a bad thing, right? You have to be pretty staunch, hardcore First Amendment's right person to say that, no, we want that speech on certain, higher elements in society and not conducted in the skeevious elements of the dark world. It's not like that went away just because we, now made it civilly liable. Those conversations and that conduct still happens. It's an evil in the world like terrorism that we're never going to completely rid 100%. We obviously want to, but it's not like the speech goes away. It just goes to it just goes underground at the end of the day. And it's really controlling what we say as a society. So if you start making platforms liable, it just starts controlling the free flow of ideas in discussions that are happening online. So I think we can do more to eliminate certain things, certain evils that are present that I don't think anyone can agree with, that should happen, and we can eliminate those aspects. But the other side of the coin is we do have to be very careful, because there is a butterfly effect where it just all of a sudden Facebook will disappear overnight, right? Or something else will happen because of fears of liability and those types of things. So,
Tom, is there any reason why we should apply different rules to Facebook and Google than we apply to Ford, in terms of its responsibility to be proactive in identifying and preventing harm to its users?
Yes. Well, I guess let me say this. I'm not sure that we are applying different rules, right? I don't know that the structure of allowing the free flow of information on a platform is necessarily a product defect. So, it's much different than if there's a faulty seatbelt. This is, Facebook allows people to post and use its platform. It's got billions of users.
Maybe you could add color to how that fits the Grindr case with the product liability argument.
Yeah, so the fact that a person is sort of misusing the design of the product, right? They're creating fake profiles. They're doing things that the platform is not intended for. I don't think that allowing Grindr to escape liability under those circumstances is much different from a products case, where there's not a foreseeable misuse of the product.
But under 230, the process of allowing a plaintiff to test whether they really had the ability to know or not know is at the door, because they get a free ticket no matter what. Even if you had evidence that said, just like in a product liability case, here's what the other platforms are doing to prevent this kind of abuse that you didn't do, the sort of state-of-the-art defense. But under 230, doesn't matter. If you could be 10 years behind the curve, you have no liability, right?
Yeah, but again, that's it's a feature, not a bug, of Section 230. Because without Section 230, you probably don't have Grindr in the first place. You probably don't have Tinder in the first place. You don't have Facebook and social media as we know it in the first place. And so again, Section 230, just like an anti-SLAPP statute, reflects a policy decision that we've made, right? In that we want to encourage speech, we want to encourage debate, and in the context of 230, we also want to encourage platforms to police their content to a certain extent, which without 230, they have no incentive to do, because they're at a much higher risk of being found to be the provider of that content in the first place.
Is there any discussion ongoing now about changing 230?
Not that I'm aware of, any more than after they made the revision of the child trafficking.
I'm not aware of anything either. I mean, I think what you're seeing though, publicly at least, especially after Russia started meddling in our elections, is that these platforms are being held accountable. People are looking at them and they want answers. Why didn't you stop this? Why aren't you doing more? And I think that we need to really put their feet to the flame and demand that they do more, because they're granted such amazing immunity under the statute to do that. And if they don't do more, they're going to lose it. And I think that needs to kind of be the gist that the problem is that the law has created these consequence is that there's an evil underbelly of the internet that's popped up that's taking advantage of these immunities. Companies now are free to extort people and money in a legal way. That's come across with charging money to remove things and taking advantage of really malicious content out there that they don't have to do anything about. You know, they can leave it, they can take it down, it's completely under discretion, and then they demand money for it. So that it's created problems, but they're not so widespread that I think these issues are demanding a change. But we really need to publicly just put pressure on these companies, or otherwise it does need a change. It does become too problematic. So,
well, unfortunately for us, we don't have time to talk about the right to be forgotten and the joys of living in Europe. Maybe at our next topic. So, but don't forget to watch us. The replay on Facebook Live. Thank you, Tom. Thank you, Aaron, for your thoughts and your contributions today. Very interesting. Thanks for all those who watched, and we'll see you next month.
thank you.